Morning, everyone. I'm Álvaro Bueno Flores. As a project support officer for the Africa IP SME Helpdesk, I want to thank all the participants for joining this session. Today, we will present the webinar Protecting Your Trademarks at the OAPI. After this session, you'll have learned about the key updates in the OAPI system after the amendments to the Bangui Agreement and the main changes in trademark registration. This will be illustrated by a case study showcasing the employment of the new trademark composition procedure. And this webinar is organized by the Africa IP SME Helpdesk, which is a free of charge first-line service that aims to strengthen awareness on how to best protect the IP assets of European businesses when expanding to Africa. This project is financed by the European Commission and implemented by the UIPO through the F3P project, which is a cooperation project focused on IP in African countries. Here, we develop service intelligence in cooperation with a network of IP lawyers, such as our speakers here, which are practicing in various African countries in order to provide the most relevant business information. Through this service, we provide IP resources such as country fact sheets, case studies, IP guides on IP protection in various African countries, and we also have a helpline service where you can ask your questions about IP in the region, and trainings such as this one, Protecting Trademarks at the OAPI, and up-to-date news and frequently asked questions on IP in Africa. So our speakers today are two excellent IP experts, which we have had the pleasure to work with before. They delivered a webinar on customs protection in Kenya in May, whose recording you can find in our site. And they work at IP Vocat Africa, which is a IP law firm based in the island nation of Mauritius. Firstly, we have Nora Hotunam, which is a lawyer focusing on anti-counterfeiting matters in Africa and specializes in the enforcement of intellectual property rights. She previously worked in South Africa and the Gambia, and she holds a doctorate in law from the University of Pretoria, South Africa. On the other hand, we also have Mario Schneider, the founder and director of IP Vocat Africa, which is the law firm focusing on the protection, management, enforcement of IP rights all over Africa. And he assists the clients in setting up and enforcing their IP strategy across Africa. Also good to note that he co-authored a publication of the enforcement of intellectual property rights in Africa by Oxford University Press, and serves in the INTA Anti-Counterfeiting Committee, the UIPO Observatory, and the ECTA Anti-Counterfeiting Committee. So indeed, Nora and Marius are the best place to give us some practical tips for SMEs that are looking to protect their trademarks in the 17 countries that make the OAPI, and learn how to make the most out of the updates in the OAPI IP system from the amendments to the Bangui Agreement this past January. So therefore, let's leave the floor to speakers who will start sharing with us their knowledge on these topics. So Marius, Nora, if you are ready to share your presentation, the floor is yours.
Thank you very much, Alvaro, and thank you very much also for inviting us to this seminar. Let me just get the good view. So yes, indeed, we will be speaking today about OAPI, and here we have the OAPI member states that are on your screen now. So you can see from the map, I'm not going to enumerate them all, it's 17 member states. It's essentially, one can say, West African Francophone countries which form part of the OAPI, with the exception being the Comoros, because the Comoros are, as you can see on the map, not exactly in that West Africa part. They are in the Indian Ocean between Mozambique and Madagascar there. So otherwise, you know, OAPI is quite an important number of member states and economic powerhouses of Africa. Maybe one has to come back to explain what OAPI is, because maybe not all our listeners today know about OAPI. OAPI is an acronym for the Organisation Africaine de la Propriété Intellectuelle, so African Organization for Intellectual Property. And they have a long history, because the first treaty dates back to 1962. Back then, it was a union between 12 African IP offices, as well as the Malgache IP office. And in 1977, the OAPI, as we do know it today, has been created. The OAPI has unitary IP rights. So you can compare this a little bit, if I may say so, to the EU trademark, which is also, as you know, a unitary IP title. But the OAPI, unlike the EU system, which is a unitary system only, if I may say so, for trademarks and designs, the OAPI has a unitary system for all IP rights, that is to say, trademarks, designs, patents, commercial names, etc., and has also harmonized copyright and unfair trade practices. So it is quite a precursory system that exists there in these OAPI states. Maybe just to finish this big little introduction, there is another system in Africa, which is the so-called ARIPO system. That's essentially East African Anglophone countries that have united in this ARIPO system, which is not a system of unitary rights, but more like a system where applicants can pick and choose countries in which they want to protect their intellectual property rights. So if I may say so, please pardon the, that's easy language, but it's kind of a mini Madrid system in Africa. So, well, this is to just explain a little bit, set the scene, and we are now looking into the changes that have come about.
Yes, so we're looking at the changes in the Bangui Agreement. So what's a Bangui Agreement? The Bangui Agreement, it's the legal framework. It's the instruments that governs the intellectual property rights in all those 17 OAPI member states. So we're going to be talking today of the recent revisions. It's actually the second time the Bangui Agreement is being revised. The first revision was in 1999. And the second round of revision actually started in December 2007 and was finalized. The signature of those amendments was finalized on December 2015 through what they're calling the Acte de Bamako. So in this revision, so finalized in 2015, but it is on the 14th November 2020 that the revised Bangui Agreement and some of the annexes came into force. So these are the annexes concerning geographical indications, copyright, protection against unfair competition, and protection of plant variety rights. Recently, that is at the beginning of the year in January 2022, then trademarks, industrial designs, and the commercial names annexes came into force. So what we're still waiting to come into force as patents, utility models, and layout designs of integrated circuits.
Okay, so let's look at all these changes. And first of all, let's look at the umbrella changes that apply to all intellectual property rights. So first of all, the revised agreement provides now the possibility to resolve IP disputes through arbitration and mediation. Of course, you know that this is a tendency. We see the same thing in Europe. And so this is only a normal evolution because, one has learned over the years that IP disputes that drag on for long in courts, time consuming, consume money and resources, and it is better to resolve this type of IP disputes, let's say, by mediation or arbitration. Also because we all know that in IP, there's never really a winner or loser. There's always one party that has prior rights in one territory or another. And so it is always a good idea to try and sit down and resolve these issues, let's say, as amicably as possible. So this has been provided for, possibility of arbitration and mediation. Unfortunately, it is not yet operational, but we're thinking this is a matter of months, hopefully, for it to come in force. Another important change is that it is now possible to have co-ownership of different intellectual property rights. I was a little bit surprised to see that because we have already come across IP rights that were co-owned in practice by two different either persons or companies. So, well, this has just been officialized now, and it's now officially possible, and there's a legal framework now for this. So that's good news. Other really great news is that electronic filing for applications for intellectual property rights and for all intellectual property rights is now available. So it's effective today for trademarks and industrial designs as of the 1st of January of this year. And one has to say that this is a really positive development. Why? Because until recently, it was a paper system. So you had to file a paper application. And of course, we all know that paper is probably more fragile than electronic databases. In Africa, by the way, you have a lot of countries that still have paper registers and no electronic registers. And these, let's say, paper registers are always rather fragile when it comes to floods, fires, civil unrest, which is unfortunately a problem in some African countries. And so it is not uncommon that right holders have to, in some countries, reconstitute their IP right portfolio whenever there was a fire in the IP office. So good news, this is now at the OAPI level, all electronic, and I think that's great progress, and OAPI is to be commended for that. Another important change, again, that applies to all intellectual property rights is that now there is a system of international exhaustion in place in OAPI. What does that mean? It means that a trader can bring in goods from other countries into the OAPI, and the right holder, if these goods are, of course, authentic goods, cannot object to this. I think it's fair to say that this is good for consumers because it brings down the price level of certain goods. International exhaustion is consumer friendly, so voila. So I guess again, OAPI is to be commended for this. Then the last umbrella change that we want to highlight here on this page is the inter partes opposition procedure, which is now possible pre-registration. That means before a trademark is registered. So previously, and we'll talk about this a little bit more in the practice point that we have at the end of the, let's say, seminar. Previously, the opposition procedure was post-registration. So applicants got a trademark registration, and only then the trademarks were published for opposition, and third parties could oppose. And this led to certain difficulties because then these trademarks are on the register. As opposition procedures could drag on for quite a long time, this could lead to problematic situations where infringers could own trademarks, without the right holder being able to do much because the opposition procedure dragged on long. And also right holders were not really informed of the trademark filings by infringers because, of course, they were only published at the same time as they were granted these trademark rights. So this is good news that now for all intellectual property rights, there are inter partes opposition procedures which are pre-registration. So that's great news. The anti-counterfeiting mechanism has been strengthened in the OAPI. So the good news is there is now a system for border measures that should be possible at the national level for all counterfeit goods. So the member states in OAPI will now have to implement a system where customs can enforce intellectual property rights against infringement. So that's fantastic news because until now, unfortunately, that has not been operational in a way that we know it in Europe, if I may say so. that is to say, you know, a proper application system for customs enforcement. That has not been the case in any of the OAPI countries. Some countries did provide for MOUs that could be signed with customs, but, you know, it wasn't a fully fledged system as we know it in the EU, so in North America. So that's again very good that this mechanism for border measures will be available. There's also now increased penalties that are provided, fines, and also there's tougher rules now on the determination of damages when it comes to repairing infringements of intellectual property rights. So that's actually great news, and I think we will see a lot of movement there in the coming months and years, and this will lead to a strengthening really of the IP rights. Also, in the same vein, if I may say so, it is now possible to have information or discovery proceedings for infringements of trademarks, patents, utility models, and plant variety rights. This is a possibility for the right holder in a court action to claim information on the infringing activities, and this will, of course, strengthen again the rights of the intellectual property right holder. Interestingly, for trademarks, the Bangui treatment says that the court may, subject to a penalty, so under a penalty, order production of information and documents that will allow determination of origin and distribution routes. That's rather vague. Fortunately, for patents and utility models, it's a bit clearer because there the right holder can claim the name and address of producers and manufacturers, suppliers, and wholesalers, as well as the quantity dealt with and the prices obtained. So interestingly enough, for patents and utility model, the information that a right holder can ask in these discovery proceedings is much more detailed. So yeah, good news for patent and utility models owners, but also good news for trademark owners because they can nevertheless ask information on the origin and the distribution routes, and hopefully, you know, the case law will interpret this, because it can be interpreted with a little bit of goodwill. It can be interpreted as well quite large. So let's hope that there will be some kind of unified approach to these two different discovery measures that can be obtained. So that's what I wanted to say on the umbrella measures, and I give over to Nora.
Yes, so I've been now focusing more specifically on the changes brought about in Annex 3 that concern trademarks, service marks, etc. So one major change is that you're not allowed to do a single application at the OAPI to register a mark for both goods and services. I think you better understand this change if you understand how it used to work previously at the OAPI. So at the OAPI before, if you had a trademark that you wanted to register for both goods and services at the same time, you couldn't do so on one single application. You had to file one application for your trademarking for goods, and then you filed a separate application for your trademarking services. So now that's changed. You can do only one application and for that one trademark. And I think it's also good because it makes much more sense, because at one point, you do know that it is possible to designate OAPI for the matter citizen. If you were doing like an international registration, you could designate both goods and services in your application. But if you were choosing to do an OAPI registration, you couldn't designate both goods and services in your, you couldn't choose both goods and services for your application. So I think it just makes things more clear, make more sense to have like a uniform approach at the OAPI now. We're also seeing that there is no more this distinction between color or black and white mark. Again, better explained by reference to the previous procedure, which was to say that before there used to be a supplement if your trademark was in color. Now the supplement has been removed, and whether your mark is in black and white or color, it's the same price. And actually, official fees have decreased in general if you're doing a trademark application at the OAPI. There's been a reduction, I think, between 20 or 30%, depending if we're in color, black and white, etc. And also one thing that they've done now, if you have a small mistakes in your application, like if you've done a typo, you've put a B instead of a P, etc., you can rectify it free of charge at the OAPI now. They've also opened up the type of trademarks that can be registered at the OAPI. So now they are accepting sound marks. So that's like musical phrases, sounds are accepted. They are accepting series marks. So what are series marks? So series marks are different, but trademarks that are different, but presents certain commonalities, certain common elements, and therefore do form part of a family of mark. I'm going to give an example. Maybe you have a trademark for water bottles, and you want to use your trademark maybe in red for sparkling water, and you want to use the same trademark in blue for still water. So you can register it as a series mark. Or you are the owner of a product, maybe your trademark is usually in blue, but now you're launching an organic, the organic range of the same product, and you want to use your trademark in green to kind of indicate to the people, look, it's green, it's organic, it's natural, etc. Or another example of a series mark, if you have maybe a cartoon that is a bit of your mascot, your trademark for your product, maybe you can register your cartoon in different poses, maybe sitting, standing, etc. Through one series trademark. So that's one thing that's now being admitted. And the third new type of trademarks, it's the collective mark of certification. So it's a bit, to be honest, a confusing name, because then one is like, is it a collective mark or is it a certification mark that is now being accepted by the OAPI? So it's in fact a certification mark it's in fact a certification mark. So what's happened is before the OAPI, it was only possible to register collective mark. But in practice, if you had a certification mark that could fit in the collective mark framework, they would register your certification mark as a collective mark. So now they've created that collective marque collective de certification to now register certification marks. So we do know that they actually mean certification mark because they in the instructions manual that come a bit with how to deal with these things, they list collective marks and then they list marque collective de certification. But it would have been hoped that the name itself could have been changed to be a little bit more clear about what exactly we're talking about now. So still on the changes regarding trademarks. So one thing, again, let me look at what was formerly the case, and then we'll pick up the changes, and then it's easier and clearer to see what's changing. So formerly, if you did a trademark application at the OAPI would only verify that the sign was in conformity with public policy and morality, and that it did not contain official signs of a state or intergovernmental organization, unless, of course, you had been authorized by the state or organization concerned. So now the OAPI is going to be verifying much wider range of conditions of validity for your trademark before accepting your trademark. So the OAPI is going to look at, is your trademark distinctive? Does it fulfill its functions of attribution? Is it not descriptive? Is it showing the commercial origin of a trademark? So they're going to look after that. They're going to look if your trademark is misleading the public. They're going to request that your trademark, they're going to verify that your trademark does not reproduce, imitate, or contain amongst its elements a common name, that it does not reproduce, imitate, or contain among its elements an international non-proprietary name. So quickly, what is an international non-proprietary name? It's the way that pharmaceutical substances will be labeled, will be named. So as an example, paracetamol is an INN, so you cannot register a trademark containing the word paracetamol at the OAPI. Also, you don't reproduce, imitate, or contains among its elements a geographical indication, and also the formal requirements of public policy and morality and of the official signs.
Yes, that was very clear. Is that for me? Hey? So now I've already talked about this, but it's really an important change. So we have to talk about it again, specifically for trademarks. Formerly, the publication was post-registration, so trademarks were published after their registration for the opposition period of 6 months. So what is clearly the problem with this is that, let's say, owners of prior rights were only made aware of conflicting trademark applications at a stage where they were already de facto registered. And that constituted a real problem because it allows infringers to be covered by, if I may say so, by a trademark registration and to hide behind a trademark registration. We will talk about this in the practical example. Now, the new procedure, which came about due to quite a lot of pressure of right holders, is that the publication will now take place within approximately 2 months of the filing of a trademark application. So that is, in actual fact, during the examination stage of a trademark application. And there will be a in that period also that OAPI will, as I say, examine the mark. And it is during a 3 months opposition period that an opposition can be initiated. And, so in other words, they are coming now to a system which is a little bit like the system in Europe and probably actually more like everywhere else in the world, that trademarks are opposed prior to being registered. So that's good news. Okay, so yes, so sorry. Previously, when you had a situation where an infringement was committed in the OAPI, so where you wanted to go after an infringer or a counterfeiter as a right holder, you needed to produce a certificate of non-cancellation and non-lapse in order to initiate legal action and in order to initiate a counterfeiting seizure, so saisie contrefaçon. Donc, in other words, it was necessary to obtain this certificat de non-déchéance et de non-radiation. That took a few weeks to obtain, actually, because you needed to file an application with the OAPI, they needed to process that, and then you needed to get into possession of the original document, and only then you could initiate legal action. Of course, that does not make sense because you want to be able to go after an infringer straight away. So this requirement has been dropped. It's no longer necessary to obtain these documents before initiating a counterfeit seizure and a legal action. Okay, also interesting now, it's possible to act against an infringer on the basis of a trademark application. It is, how does it work?
So,
Thank you.
So if you have an act that has been done prior to the publication of registration of a mark, it cannot be considered infringing. Someone cannot infringe your trademark if he's been doing acts against your trademark prior to the publication of a registration. However, once your trademark has acts which are done after the notification to the suspected infringer of an official copy of a demand for registration, can be prosecuted. So, however, what the court will do, so you can notify the infringer and say, look, this is a copy of my demand of registration. I'm notifying you that what you're doing is infringing, and you can lodge your case into court. However, what will happen is that the domestic court will not pronounce itself on the matter until the publication of the registration by the OAPI. But at least it's providing, I mean, if you if you maybe didn't think of registering your trademark before, then you saw the infringement. So it's allowing you to move forward without waiting for the whole period of a registration process to go through. And maybe, who knows, a notification sometimes is enough to stop an stop an infringer. So
thank you very much.
There's one major change actually that's going on for geographical indications. So as some of you know, so what is a geographical indication? It's a sign that is used on products that have a specific quality, a specific characteristic based specifically on their geographical indications. So it's interesting to note that the OAPI has geographical indications legislation for a very long time. I mean, in 1977, as Maris was saying, it's been quite some time. They had appellations of origin, but it's the second revision that I was talking about in 1999 that really brought about geographical indications. So it's interesting. So maybe some of you don't know, but the first geographical indication that was registered in the OAPI was actually in 2006, and that was actually Champagne. But the first geographical indications from the region, from the OAPI region at the OAPI, that was only in 2013, and that's the pepper of Peña. But increasingly, there's more and more geographical indications coming in. And one major innovation that they've done through this Act de Bamako, the recent amendments, is to say that now you can have a GI that is recognized for one or more member states, so that you don't need to limit. Very often, what's usually the case for GI is a GI is limited to a particular region in a particular country. But the OAPI have now said you can have a GI that crosses a country, that multiple countries will claim as their own. And I think that makes a lot of sense. If you look at how the borders of Africa were drawn, the borders were drawn arbitrarily. So you could have the same culture, the same community that could be on different sides of borders, different countries, but their culture is the same on both sides of the borders. So this change by the OAPI is actually very much a reflection of the circumstances, the specific circumstances that we are in Africa. And I believe it's a very good thing that the OAPI has really looked at the local situation and found and chosen to move forward with an amendment that is actually quite uncommon for a GI, but that actually responds to the needs and to the needs and to the situation on the ground in the OAPI. Moving on to copyright. So before, what you used to have was that you had for copyright, the annex, the rules under the annex were considered as a common system. That means they were simply indicative. So it should be noted. So interestingly, we've talked about trademarks, for example. So if you go to an OAPI country, you will notice that they don't have a domestic trademark legislation, and they're applying the OAPI that annex. But if you looked at copyright, all the different OAPI of most of the OAPI member states had their own specific domestic copyright legislation, and the annex was simply like an indication of how they should draft their copyright laws. But now there's been a change. The Annex 7 is now the minimum regulatory framework, which means that all states must adopt at least what is provided for under Annex 7, rather than having rather than it being simply an indication that it was before. So what should this mean in practice is that any countries that have a law or a provision that is underneath Annex, or what is provided for in Annex 7, well, this law and this provision should no longer apply. It should be the provision provided for in the Annex 7 that should apply in the country. So that's a very welcome development of the OAPI, because simply, I mean, it is a matter of simplification of the system. Copyright was the only IP right that had not been fully harmonized among all the other IP rights that we've been talking about. So nowadays we're having really this minimum requirement for copyright, so right holders kind of know what to expect in all the different member states nowadays. Yeah, that's great news. And I mean, it's for our European friends, it can be a little bit compared to a harmonization directive as we know it in Europe for a lot of IP rights, or as we knew it for a lot of IP rights. So yeah, great to see that Africa is
a precursor because the OAPI system is older than the EU system and is applying to more rights, but that they can continue to keep updated and that they can continue to evolve. So that's fantastic. That concludes our presentation. We have prepared a little case study. The case study actually focuses on the problem that I have explained relating to the opposition that was post-registration under the previous system. So we have, we have actually not really come up with a case. It's actually a real case that we are talking about. You can, if you have access to the OAPI case law, you can read a lot about it. So there's a company A that had registered the Drinko-Pop word mark going back to the 1990s for flavored milk in OAPI, and the products were commercialized, all around the OAPI region. And of course, it was an attractive trademark. So what happened is that there were a lot of people who had the idea to imitate it and to come up with an imitation, which was actually the pop drink trademark, also for flavored milk drinks. And so the company A did successfully oppose the registration of a pop drink trademark for flavored milk at OAPI in the name of an individual, Mr. X, as well as a company Y on the basis of its former trademark. So first opposition case was successful against Mr. X. The problem which we can see here already is that after a successful opposition procedure, because there is no examination for relative grounds in the former OAPI system, somebody could just go ahead and reapply for the same trademark again, and then the right holder would only be made aware of that application once it was already a registration. So this is clearly, or this was clearly a problem. And this is a real case. So company A did once again oppose this second pop drink trademark application in OAPI, and they did also, in parallel, they did start also infringement proceedings in 2 African countries. So the problem with the opposition proceeding, let me go back to that. The problem with the opposition proceedings is that, as I say, they do drag on for a little while, because there is, at the OAPI level, there is first a decision by the Director General of the OAPI in first instance. That takes, I would say, approximately a year to be reached, and then the trademark applicant, or actually registrant, could file an appeal, and then the matter would go to the Commission Supérieure de Recours, so appeal instance, which took another minimum a year until there was a decision. So, the trademark that the trademark that's opposed and that's considered to be infringing by the prior right holder is on the register for actually quite a while. And that has proven to be not only a problem on the paper, but actually when it comes to infringement proceedings, that has proven to be a problem as well, because we have seen in 2 legal actions that were started against the use of a pop drink in Niger. For example, in Niger, the judge first granted a counterfeit seizure, saisie contrefaçon. The counterfeit seizure was executed on the pop drink products, but then the owner of the pop drink mark did file a third-party opposition. As you know, a counterfeit seizure is a unilateral procedure, so the alleged infringer is not informed of the request filed with the president of the court, who will then hand down the decision on the counterfeit seizure. So as they are not party to this proceedings, they can do a third-party opposition, which the owner of the pop drink trademark did. And on the third-party opposition, the judge lifted the counterfeit seizure and said, no, no, you don't have a right to this counterfeit seizure because the trademark is actually registered. So, but clearly it's a bad faith registration because it's the second time that Mr. X was applying for the trademark. And but it led to this type of situation. In Togo, more or less the same situation where in an infringement procedure, the judge said, no, you cannot take action against this infringer because the infringer actually is not an infringer. The infringer owns a trademark registration. So you see, this situation did lead to difficult situations. We have, in the case of Pop Drink, bitterly complained to OAPI, and they have then therefore adapted the system. And as we have already explained, I don't think we need to tell it 10 times again, but as we have already explained, it's now a system where there will be a substantive examination. So, OAPI can also, on their part, examine whether a trademark has been repeatedly filed. So if somebody comes and repeatedly files an infringing trademark, OAPI could, if they wanted to now, take themselves action and during the examination phase refuse the mark. And there is now, of course, luckily also a opposition procedure that will allow right holders to become aware of a trademark application as soon as it's filed and published for opposition, a little bit like in the EU, where actually when somebody files a trademark in a watch notice, the mark will be picked up from the first day of the filing. So that's good news, and then the right holder can oppose these trademark applications, and it'll be smoother and more easy to go against infringers. So that is for the case study. Now we are open to questions for the public.
Okay, thank you very much, Marius and Laura, for the very informative presentation. I think it's you have given us a great presentation how to make the most of the IPA system and its respective updates, of course, with this focus on trademarks, illustrated by this case study you have just presented. I'm sure that the audience will appreciate the knowledge you have shared with us, and if they, of course, they're interested in expanding in one of these 17 countries. So I want to take the chance to move on to the questions that we have received on these topics previously. So I'm going to go ahead and ask the first question to you, which is, can a foreign geographical indication be registered in the OAPI?
Yes, you can register. If you're a foreign right holder and you want to register your geographical indication OPI, this is possible. This applies, of course, to the goods that are much more traditionally under GI, food, drinks, spirits, etc. But at the OAPI, you can also register handicrafts, for example, as a GI. Of course, there's a few requirements if you're a foreign right holder and you want to register your GI at the OAPI. For example, you need to have that GI registered in its country of origin for you to apply for its registration as a GI in the OAPI. And also that, for example, the GI is not only registered, but is also being used in your country of origin, like it hasn't fallen into disuse in your country of origin prior to you coming to the OAPI, of course, and then the usual, when you have to file the filing fees, you've got application forms, etc., etc. But it's something that is definitely possible.
Okay, great, thank you for the reply. If you're in the area of IP, you know that GIs are pretty much a relevant topic now, and it's very much being promoted, at least from the project from Afripi. We're doing quite a lot of activities on this and raising awareness since it's rising in relevance. And I'll move on to the second question that we have received is that the production of the certificate of non-cancellation or the certificate of non-lapse is no longer necessary to obtain the order of the seizure. And does this mean that the certificates no longer exist?
No, so you don't need to produce the certificates anymore, but they but they do exist. Nothing will prevent, for example, the defendant or maybe even the court after the seizure has been undertaken to say, okay, now please bring us the certificate of non-cancellation, bring us the certificate of non-lapse. But simply as Marissa said, sometimes these documents used to take a few weeks to be obtained. Now you can just move forward with your seizure, and maybe at the same time, if you maybe believe that the court will request it from you at a later stage, you can ask for it already. But the certificates in themselves will still be there, and the OAPI will still issue the certificates.
I mean, it is a pity, to be honest, that one hasn't, been courageous enough to do away with it and to just rely on registered extracts, because that's how it works in Europe. Of course, if you have a litigation, the right holder will just go ahead and print out databases. And if somebody doubts about these databases, well, the judge, for example, or the other party, well, they can just control it by going online and looking up the information themselves. And so this is a sufficiently good system, one would have thought. So it's a bit of a pity that one hasn't done that additional step. The more so since the register is now supposed to be online and freely available for everybody. So well, a pity, but okay, look, there's more room for future changes and for future webinars there.
Right. Absolutely correct, Marius. And well, last question that we will go for due to time constraints, is we're going to slightly over the time that was envisaged for the webinar. There's a question of who may be concerned by a search for information.
Okay, so those that are going to be concerned, for example, definitely the defendant in the court, the person that is suspected of the infringement is going to be concerned, but also people that are found in possession of counterfeited products, or who are carrying out an infringing process, or who are providing services that are used by the counterfeiters. Someone that has been reported to be involved in maybe manufacturing, transporting, distributing those counterfeit goods may be concerned by the search for information.
So as in Europe, intermediaries are now to a certain extent concerned. So it's great news.
Okay, so well, I'm gonna thank you very much for replying to the inquiries, and I want to take the chance to invite everyone to go ahead and look at IP Africa's webpage, also to take a look to the help desk website for more information, and check our OAPI fact sheet, which is only one out of the 38 fact sheets I'm counting that we have produced. You can also stay updated on our activities on the A3P and the help desk website, where we publish news. You can follow our social media profiles on Twitter, Facebook, and LinkedIn on Africa IPR, where we also publish interesting updates such as this and the facts of IP protection in the region. There we will also promote our future webinars and upcoming events. And to finalize, I want to thank all the participants for attending this webinar, and we truly hope you have received the useful information this morning. Marius and Nora, thank you once again very much for providing us with your expertise, your effort, and preparation for the webinar. So have a nice day and a nice week, of course.
Thank you very much.
Thank you very much, Alvaro.
Goodbye.
Bye-bye.
Thank you. Goodbye.